My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're continuing our video series designed to inform the public, so please subscribe to our channel. In the context of custody, there's really two types of custody. There's the physical custody and the legal. Physical custody is easy to explain. It's basically where the kid sleeps at night. Legal custody is a little more complicated. We're going to focus on that today. Legal custody has to do with the major decision making regarding the child. I don't mean what color pants the kids wear, what kind of shoes you send your kids to school with. I don't mean that. I mean medical decisions, educational decisions, religious decisions. These are the kind of things that when there's a joint legal custody, the parents have to get together on. They have to agree on these fundamental decisions. If the parties have joint legal custody, that doesn't mean that the parent, who's the non-custodial parent, but who has half legal custody, gets to weigh in on what friends the kids hang out with, or necessarily they get to decide what kind of clothing the kids are going to wear. The ticky-tacky stuff is not part of legal custody, okay? Because day-to-day decisions have to be made by the person with whom the children live most of the time. I'm talking about fundamentals. So one of those fundamentals is schooling. And it has become more and more of a thing since COVID. Why? Because since COVID, people realize, kids can educate remotely. Kids can be homeschooled successfully. All these kids, when the governor shut us all down, all these kids were attending school by Zoom. That means something. That means that the average 8-hour a day that the kids in attendance in live school could probably be condensed to a homeschool situation in maybe an hour or two. So what happens if the parties don't agree on in-person or homeschooling? What do you do? Well, you have to understand one thing. There's a very strong social component that could be a very positive thing to attending school in person. Parties have to talk about that and determine if we're going to homeschool, how are we going to deal with the loss of that vital social component. I would venture to say that in certain years, the social component is even more important than the scholastics. So how do we deal with that? Well, let's say the parties discuss it and they can't agree. If you cannot agree on to homeschool or not to homeschool, you know what you got to do? You got to contact the lawyer. Lawyer's got to file a particular motion before the court, and that motion basically says, look, we need a decision about schooling. This one wants homeschooling, this one doesn't. It's joint legal custody. What do we do? Now, if it weren't joint legal, if one person got to make all those choices because they had legal and physical custody, you really wouldn't have a whole lot to say about it. I mean, ultimately, it would be up to the parent who has the full legal custody to make the decisions that's in the best interest of the child. It would be a tougher call to get the court to interfere with that. But in a joint situation where the parties cannot agree to homeschool or not, you have to file a motion before the court. The court will conduct an evidentiary hearing to determine what's in the best interest of the child. What's the reason to homeschool, or what's the reason not to homeschool? And then the court will make an appropriate ruling that makes sense for your child. If you have any questions about that, reach out. We'll be glad to help you out.